who are complaining so much about privacy laws, and you now know about the Murdoch Empire and this really extraordinarily corrupt relationship they have with the Metropolitan Police. And then that's why you know why you need judges. And although privacy sounds like a bad thing, why shouldn't we have a private life? If I want to go cottaging on Clapham Common, why does it have to be publicised everywhere? But I didn't really want to talk about UK domestic legislation necessarily. There is also domestic legislation for other countries. So the point blank being international law being, say, things like Geneva Conventions and the rules between governments, and then domestic law, which is just another word for local national law. So, for example, in Kurdistan, the northern region of Iraq, they've just found loads of dead bodies and they want to publicise the fact that there's been a genocide. A genocide is an international crime, so in theory, when they've got that evidence, they can use that to have a go at the Baghdad government. But admittedly, it's the Baghdad government under Saddam Hussein. But that's an example whereby international law, namely the concept of genocide, can be used by a national people, namely the Kurds in northern Iraq, in order to enhance their history, possibly get compensation, and put their grievances on what you might call the international map. And why is that important? And I was talking about it last week because there's a possibility it could repeat itself. There could be another Kurdish genocide because things in Iraq are still very tribal. So it's important to think the Kurds in the Kurdish region of northern Iraq to document and have recognised the Anfal, as they're called it, which was the attack over a period of time by Saddam Hussein, who killed different estimates, anything from 80,000 to 250,000 Kurds who were found in mass graves. So international law, the concept of genocide can be used in order, in a very practical sense, to enable an emerging country like Kurdistan, or the it's an autonomous region really, it can be used to enable them just to preserve their existence. Again, the Palestinians is another one. Just the Kurds, just historically, of course, unfortunately, the Kurds participated in the massacre of the Armenians. So, in fact, Kurds have been partly perpetrators of genocide themselves, and that's something they're going to have to recognise, and that's something called the Turkish genocide, which, if you're interested in international politics, Turkey gets very angry and you can get sent to prison if, in Turkey, you stand up and say there was all the Armenians in Turkey were killed, which they were. That actually is an imprisonable offence. And people have been sent to prison in Turkey today, modern, for asserting that there was indeed a genocide. And there was a genocide perpetrated by Ataturk, I think, in between the walls, around then. And it has to be said the Kurds helped them do it. But now, so everyone has a history of genocide to a certain extent, but these can be useful ways of using international law in any number of domestic legislation. Finally, and then I'm going to have questions and any ideas, and I really want to talk about other things. Libya. Why is it a problem for Saddam Hussein to retire? And the answer is that neither is a warrant for his arrest by the International Criminal Court. He has to be arrested at some stage by countries. Sorry? Gaddafi. Sorry. Thank you. I mean Gaddafi. Yes. Sorry. Yes. Right. Gaddafi. Thank you. Has to be arrested. Can't be allowed to retire. You may say that Libya is not a member signatory to the Rome Treaties to recognise the International Criminal Court. The answer to that is, though, that the warrant issued has been issued under the auspices of the United Nations. So, in theory, any country that's a member of the United Nations should have an which includes Libya itself, and any future government of Libya should be obliged, subject to UN sanctions, to hand over Colonel Gaddafi. So that is an interesting problem where those who call for instant action by the International Criminal Court might make it difficult to have reconciliation, and the same is said in Sudan. So there are those who argue that the newly created international criminal structure, which is a great thing in many respects, can be a hindrance to peace and reconciliation where we're trying to get rid of a dictator. Anyway, that's my little pitch. Has anybody any idea, questions so far? Any areas of international law? Ian?
Well, I'd like to propose that the international court's a load of bullshit. From the moment that they fail... I'd like to put it to you, Hugo, that the international court's a load of bullshit from the moment that they failed to indict Tony Blair and George Bush for invading Iraq. In a clear breach of international law, they faked documents, they lied, they broke the United Nations Charter. Kofi Annan determined that. Who would be the best, person to interpret the United Nations Charter? I would have thought the Secretary General of the United Nations. I put it to you, Hugo, that sadly, I must, of course, we all were very glad at first to see the International Criminal Law. It's just been completely corrupted by the personnel.
Well,
personnel stooges of the CIA.
I think a more obvious or legally obvious target than Tony Blair is the Bagram Air Base. Well, there's undoubtedly torture is used at Bagram Air Base. And I think that, yes, too.
There was no emergency that justified there's no emergency under the United Nations Charter that justified the invasion of Iraq. It was a clearly illegal act.
Thank you for asking me that. That brings me on to another aspect of international law where it can be used in a case that I did, defending people who tried to sabotage some B-52 bombers at RAF Fairford. Some of you have heard that. And they didn't get very far, but Margaret Jones, we tried to argue they were acting to prevent a crime. And that required defining whether or not the invasion of Iraq was a crime. And the original story about that was Margaret Jones, the way we got... And so Margaret Jones was saying that when she was trying to do the damage that she did, she was acting to stop a crime, and we had 6 trials on that and won 5 out of 6. And it started because originally she used this idea when she, on Hiroshima, the full moon on Hiroshima night, she and some friends, ex-Green and Corn, were snipping the wire fence at Aldermaston. And they were stopped. And they were basically to protest. However, Aldermaston, as Professor Busby here will tell you, leaks substantial amounts of radiation and has a much higher than average childhood leukemia. So we argued that Aldermaston was killing children and therefore deserved to be dismantled, the first stage of which was cutting down the fence. The magistrate at the end of the day said, well, cutting down the fence didn't do any real damage. So I said to Margaret, well, next time you try this, do some real damage. And I get this phone call, Margaret Jones has just done £100,000 worth of damage to bomb laying equipment at RAF Fairford. So, no, we've got a defence. That's what I call serious. And sure enough, the question was the international crime of aggression, which was the invasion, went all the way to the House of Lords, and they said, sadly, that it's not a crime under UK law, but it may well be a crime under international law. But only UK crimes count, so we didn't have that defence. But yes, no, the idea is actually it's a political body, and it's better than nothing. But someone sooner or later has to indict. Well, the crime of aggression, the mere act of going to war, is the one remaining aspect of the Rome Treaty which is not implemented. It's not a crime which the International Criminal Court can consider yet. The definition for the crime of aggression is in the process of being decided over a 10-year period. That's the one thing that hasn't. What has been brought in is that war crimes are indictable. And that was actually the defence we used for Margaret Jones. We said because the original amount of munitions they were going to drop on Baghdad in the first 3 days, they subsequently dropped throughout the entire month attack, I think. So we argued that she thought, because that would have been Dresden, about 3 times the firepower of Dresden. So we argued that that would have been a war crime, and we argued that by trying to stop that bombing, although in fact it didn't turn out to be that, the fact that she thought it was good enough for defence purposes, she was stopping a war crime. And that was in fact the defence that we relied upon and the defence that worked. We weren't allowed to say they were stopping international crime. So all this business about Tony Blair being a war criminal, not until it is passed into statute. Anything
Just quickly think something else.
I never speak for more than 12 minutes, it's a golden rule.
No, I was just, how do you say now, the Human Rights Act is enshrined in British laws, but is there not quite the same the same alignment between international humanitarian law and British law then?
British law?
Yeah.
Yes, so the extent to which the old rule used to be that if it was, there are two types of international law. There's what you call convention law, where countries sign conventions. It's a bit like statutes. And that's what current international lawyers like to talk about. And that's one of the problems, as I said, the crime question is not. But there is an older type of international law, such as Nuremberg law, which is what you might call common law or historic law. And the great argument we went to the House of Lords about was that although the crime of aggression is not defined in the Rome Statute yet, it is an existing crime under international law, under what I call international common law, because of the Nuremberg Principles. The Nuremberg Principles arose not because they were signed and agreed, but they arose naturally at the Nuremberg trials, and that created the crime of aggression. And interestingly, if you look at the judgment, the crime of aggression is the modern language for attacking another country. The words they used in Nuremberg was the crime against peace. And the modern lawyers don't like crime against peace. It's all a bit peace movement-y, Nuremberg-y. On the other hand, it represents particularly the common law definition as opposed to the statutory definition, which is currently being written out as we speak. And so we had a bit of an internal fight between the lawyers. We wanted to use the common law term crime against peace, and the new right-on, new Labour type lawyers wanted to use the phrase crime of aggression. So throughout we used two with a slash between the middle. And at the end of the day, the House of Lords said there is no difference, which is fine. I mean, that, technically speaking, is something of a result. So what about that being? So there is historic, yes, basically, in theory, international humanitarian law type things should apply automatically by way of common law in this country. The reality is, though, nowadays, unless it's been written down on a bit of paper and signed, it's extremely difficult to get anything sort of enforced. But it is a sort of medium. For example, if you wanted, for example, to use some sort of international law to complain about mass radiation, you might be able to do that.
Well, that's a human rights thing, isn't it? I mean, because implicit in the UN Charter, in the UN Human Rights Charter, is this is a. I'll just stand up and speak. No, one of the human rights items is the sanctity of your body. It's, you know, that you have the security of your body. I mean, there are various other ones, health, family, and so forth. But you have a right to the possession of your body, and you're allowed to say that you don't want it. And you don't want your body to be contaminated with something which, in principle, can kill it. And no matter how small that amount is, and no matter how very vanishingly small, if you like, it is still a finite probability, a finite possibility that this substance is going to kill you. So I should think that it seems to me that under human rights legislation, you ought to be able to argue that cross-boundary contamination from radioactivity, or even like, you know, down the road contamination from radioactivity, is an assault. And when I was in, and I should say this, when I was in Japan, what I argued, and of course that was much more radiation, that those people there who were suffering exposure from the plant, from the Fukushima plant, were actually suffering an assault. And that should be a legal position, that they should be entitled to compensation for their assault and to send the people who assaulted them to jail, or certainly have some kind of recompense. What do you think?
Well, that would all depend on the internal laws of Japan, because the truth of the matter is international laws haven't taken off. Were Japan to be a signatory to the European Convention on Human Rights, they could go to the European Court, because in this country, if you could argue that in these courts, and in theory, if you're not happy with this court's decision, you could take it up to the European Court. But I don't think Japan has anything like that. And the point is, everyone talks about international law. The truth of the matter is, it's all just really a lot of hot air, and it's only just beginning to take off. It's taken 60 years to get the International Criminal Court, and they've finally just had the first 2 trials. And yes, of course, it's all a load of nonsense, but I mean, it's more nonsense than there was before. And on the one hand, you have to set up these jurisdictions. And the minute the answer to the point is there's no enforcement mechanism except via the Security Council of the United Nations. If you could persuade the Security Council of the United Nations to set up some tribunal or structure, and that's how all these war crime tribunals are all done. So Yugoslavia, these have to be specifically set up by the United Nations mandate, and that's the nearest we get to international law. So there's only so much. Yes?
Isn't the problem with international law that, I mean, who writes international law? Then is it going to be us in the West who write it, and is it just going to kind of squeeze the smaller countries completely out of the frame? Be a way of sort of monopolising the game a bit?
Well, I'd rather it's written by the West than by the Chinese, I'll put it that way. The early answer is, the Americans, of course, tried to rewrite it with Guantanamo Bay, because one of the ways you get international law is by what's known as states practice. If it's been normally done, then it becomes an international law. That was how they set up Nuremberg. They said it went outside the normal conventions of human society generally. And so what the Americans tried to do with Guantanamo Bay and setting up this concept of an enemy combatant was to establish a new type of participant under international law, because either you were civilians or you were prisoners. And then, Second World War stuff, if you had a uniform, then you were a soldier, and if you didn't, then you were a civilian spy. And simply by calling people enemy combatants, America has tried, I think unsuccessfully, to set up what you might call a new convention under international law. But the answer to your question, who writes, so that is one way, and the other way now is people get together under United Nations umbrellas, or in the case of the European Court of Human Rights, after the war, people get together and they write it out. But yes, it's Western. I think Western values should triumph, personally, and legally.
I want to make a point about this. This T-shirt I'm wearing is a result of having gone to Malaysia. I was invited by Tun Mahathir, who's like an old Tommy, looks a bit like, he dresses like Chairman Mao. Anyway, he had a good, interesting idea, which was about legitimacy. So the question is, what is the legitimacy of the International Court or the Court of Human Rights or any of these flaming courts? And it brings me to my point about alternative institutions, separate institutions, because there's nothing to stop, argued Tun Mahathir, anybody from setting up a court with judges, and he pulled in judges from India and from Malaysia and from Indonesia, proper high court judges, people who had served as judges all their time, and they set up a court to try Tony Blair and George W. Bush, and he said to me, well, if we find them guilty, and I mean, we'll ask them to come and give their side of the story, and we'll give them a defence lawyer and all the rest of it, and do it properly, and at the end of the day, if we find them guilty, there's nothing we can do. We can't send them to jail, all right? But what we can do is we can append to their name the term war criminal. So then, if enough people then come to learn about this through the internet or from whatever source, what they can then say is, whenever they say Tony Blair, they say Tony Blair, war criminal, who was yesterday talking at the the garden party of the Queen, also war criminal. Anyway, whatever. You see the point. Alternative institutions. So the question is, if we can't get anywhere through the fixed, fitted up, legitimate courts, we'll set up our own courts. Why not?
That's a very useful campaigning tool, and I think that can be done very simply. The lady in red.
Can you film me?
Yeah, I want to hook up on that idea. We really need tribunals, but I would suggest that these are tribunals of systems, not individuals, because all people are victims of systems. Even the people who commit crimes, they are usually been born into some kind of wicked system, family, that takes some place in some wicked, in the system, in a place which commits crimes. And we can offer them rehabilitation. People can be offered rehabilitation to redo their minding and to bring them back into loving energies. It can be done with different systems. But talking about your issue of European law, I wanted to just tell a story, what happened to my tribe, to Balts, to Latvians, how we were colonized by Europe, Lisbon Treaty. And we sort of don't have any tool to reevaluate this European treaty. You reevaluate your little businesses, you sort of do different kinds of reevaluation, but when you add a European Union, you don't reevaluate what happens to people. 1/4 of my tribe, 500,000, have left our native land because they don't have anything to eat. And sort of many have died. We don't know the numbers because we have lost the ground of rule on our land, because we, the Latvians, don't rule our country. There is some kind of corporate tribe that has taken over the system. And we see as the solution to this to create the systemic tribunal of our own, to take back the power to the tribes that have been living there for 7,000 years, sort of, yeah? But there is no real mechanism how to do it, so we have to create it from new.
Yeah, well, I think that's where, for example, international legal principles can be applied.
But just before you break in with solution, I will give you the terrible thing they did. They destroyed the central bank we have. There was a rule of 8%. You have to have 8% of all the banks in the country in the Federal Reserve of the country, in the country reserve. They just overnight destroyed that rule and destroyed all documents. You can't find the documents.
Do you have euro? Do you have the euro in Latvia?
No way. Not yet. Over dead bodies.
Yeah, that's the result.
But the thing is, they just destroyed all the documents that were there to show that they commit crimes. And the guy who did this destroyed the central bank system and bankrupted all the banks. And then the foreign banks came in and occupied the territory.
Was this just after when was it?
93, 94.
Well, that's when you got independence.
Yeah.
Yes.
90 we got independence, 91. And 93 they bankrupted our banks by this method. And the guy who ran the Levitt, who was a judicial minister then, he appeared in European law, in European, what do you call it?
Commission?
In the tribunal, European tribunal, how do you call it?
Well, there's the European Court of Human Rights.
Yeah.
Or there's the European Court of Justice.
I think it was called, I had one of them, but they appealed to the European Court.
That would have been to the European Court if we're talking about an internal government mechanism that might be challenged under some sort of European. That would have been the European Court of Justice, because it's not to do with your personal. The point about human rights is it's asked about you. It doesn't deal with systems rights, and this is one of the points. Your human right is always case specific, so it's very difficult to bring a class action for human rights. But where you're dealing with a systems failure, where, for example, a bank has the rules that have been broken, that can be challenged to the European Court of Justice, because it will be in contradiction of some sort of European provision.
Okay, so they brought it there, but imagine what? The same guy who bankrupted Latvian system appeared in the European law. The guilty man suddenly was the ruler in the European court.
Oh, you mean he was on the
The
European
same
Court?
Levitt, he appeared there.
Well, this is one of the problems with
And
the
he
European, with all the
said,
European
you
courts.
have brought in this appeal too late, administrative dismiss of the appeal.
Yeah, because the judges to all the European courts are very political.
This
Even
is
the English
mafia.
judges, the
This
English
is
judges are
criminal.
usually foreign office lawyers who.
Mafia that is destroying nations.
Is there no way that you can build a higher body in
Well, can you challenge appointments? No, you can't. You can only challenge
No, not that. Can you challenge the decision on the basis that the person who made the decision was the guardian? Can you challenge?
Well, yeah,
Can you challenge that decision on the basis that one of the members of the panel that made the decision was also associated?
You'd have thought you would have been able to challenge it. The trouble again with these international courts is they answer to nobody else except themselves. So, for example, I'm on the Special Tribunal for Netherlands, but the International Criminal Court, one of the defence lawyers defending people in the Yugoslav tribunal was accused by the court itself of contempt, because when they brought witnesses, it was being said that they were falsely accused of bribing the witness. And the International Criminal Court itself locked up one of the defence team, which would never happen. And the problem is, this International Criminal Court is actually answerable to no one. But they do have power of enforcement and they have jail cells. So that is one of the problems with the various international criminal courts. They have enforcement powers, and actually nowhere else you can appeal to except to the court itself. So there are quite a lot of problems with,
What about the Parliament? Does the Parliament have any clout?
No, the International Criminal Court has nothing to do with
the European Court of Justice.
The European Court of Justice. That doesn't lock people up, that fines governments. The European Court of Justice is, again, there's nowhere to appeal to after it.
Hiya, Hugo, is there any instances where people have been prosecuted for failing to intervene to prevent a human rights abuse?
Yes. That is actually one of the fundamental principles, that is why you might take a government or your own government to court, because they are not looking after your interests. So if, for example, you've been radiated here and the court says, no, we don't recognise radiation poisoning in this country, that is exactly the sort of thing that you would make a complaint to the European Court of Human Rights, and they probably would make some sort of ruling to the effect that the government wasn't doing its duty. And they can then, in theory, force governments to protect rights. That is what the interesting, so I can come back to that, but that's one of the questions behind privacy law is it a duty only of governments to respect your privacy, or is it also the duty of governments to ensure other people respect your privacy? Sorry, your question.
Yeah, I have a little different question about the Convention Against Torture, the UN Convention. I'm from Women Against Rape, and we tried to bring a case to the European Court that the UK had breached the Convention Against Torture when they deported a woman back to Uganda, and that because they hadn't offered her redress as a survivor of torture, which there's a rule in the Convention Against Torture that you have the right to redress. And I was wondering why UK lawyers don't use the Convention Against Torture in relation to asylum claims, and if you know anything about it, because I know it's used in the US.
Well, it wouldn't be used, you couldn't get, I don't think, redress from the UK government.
Well, that was another argument that we were trying to make, because it's not completely defined in the Convention Against Torture whether it's the country where you experienced it that has that have to provide redress, or if another country that has also signed the convention should also have to offer the redress.
I mean, I think the people would say that if you're a country that's taken in someone who is fleeing torture and you're, as it were, good enough to do that, then it's a bit hard to then expect you to stump up for redress for torture which that government didn't perpetrate. I would have thought would be.
Well, we thought that the UK should, that if you have signed up to that convention, then you should be against torture and, offer help. But I was wondering why UK lawyers never use the Convention Against Torture
No, they do, right.
in immigration, in asylum.
No, yes, indeed they do. That's what the Daily Mail has gone bananas about. The reason these terrorists, if they are terrorists, whatever, can't go back is because it is said they will be tortured. And so that is why you have these control orders, that there are at least a dozen people, or 14, who are subject to control orders. This is an interesting example of how the Human Rights Act works. People who were said to be known terrorist threats, against whom cases could not be brought and who would not be convicted, were nonetheless about to be deported back to where they came from, Yemen or Pakistan. But it was argued successfully by their lawyers that to send them back to that country would result in them being tortured, and so we weren't allowed to do that, and so they had to stay here, even though they were dangerous terrorists the government didn't want. That led to what were called control orders, whereby Parliament passed a law that said people could be locked up even though they hadn't been found guilty of any crime. That statute, that law, was taken and challenged in this country, which you have to do first, and the House of Lords gave a ruling, which is all they can do under the Human Rights Act, to say that the parliamentary legislation was inconsistent with the European Convention. And that's only happened 2 or 3 times, and that was a really big deal. It was all very embarrassing. John Reid ignored it, and there's a question at the back there.
Do you think, given some time over the next 5-10 years, there's in Bolivia they come up with this Declaration of Mother Earth Rights, basically similar to human rights, but saying the earth, the planet, the trees, the rivers have rights too. Do you think over the next decade we might see some of that coming into being semi-enforceable, or?
Well, I think some of it might be. I think it's a very, very useful extension of the concept of rights, and I think it's a very useful tool, and a bit like talking about in terms of setting up one's own tribunals. Actually, these non-governmental tribunals can be quite authoritative, but the extent to which human rights, earth rights would be incorporated as a concept in any legal system, I'm not so sure, because it's such a big step. It tends to be wrapped up with the group of people who live on the land's rights rather than the concept. I can't see it coming in, only because it's so useful and radical.
Bolivia's just asked the UN, but Bolivia's just put it into the UN process, but that could take long time.
Well, yes, no, so then it becomes, once it becomes United Nations resolution, then once you have a United Nations resolution, you then can start arguing that your government is not acting in accordance with the United Nations resolution, but again, you're right back to enforcement mechanisms. On the other hand, UN resolutions certainly influence governments, and so you might get it being brought in.
Can I ask one other question? We're involved the other year with Occupying Parliament Square, and there's a guy, Chris something, who basically campaigned on the international laws of war.
Yeah.
And according to pacts that we signed in the 1930s, Kellogg-Briand Act, offensive wars are illegal, such as the ones we've had Iraq, Afghanistan, Libya. Defensive wars, you're allowed to defend yourself. But do you think we'll ever see a situation, or do you think it's totally stacked the other way, where Western countries such as the US and UK could actually ever be pulled up for their illegal wars and international, or is it set up by them and quite stacked in the West? You might cover a bit of this already. But
No, there's a current campaign going on about, as I said, it comes back to the crime of aggression. There is nothing to stop this country making it, this Parliament, or indeed the Scottish Parliament separately, making it a crime under English law to commit the crime of aggression, to invade another country. So that could happen. And it probably would in fact have retrospective effect, although that's another argument. It could happen, there are moves for it to happen in Scotland. Other countries have brought it in, so there are some countries where Tony Blair cannot go, because if they have a domestic law, and that their own national law, that it's a crime to invade another country, Tony Blair cannot go there because he will be arrested.
So wasn't there a similar recently? I think Bush or his lawyers were challenged by a Spanish judge, and Bush then was going to go and visit Switzerland, and there was a little threat that if he turned up in Switzerland, somebody might possibly try and arrest him, and then he called off his visit to Switzerland. So we are winning somewhere in some countries.
And the Zippy Litni, or whatever she's called, the Israeli minister, who called off her visit because there was a warrant being obtained for her arrest.
Aren't they changing the law to stop that?
Well, it's not actually, it's not, the only way you'd ever get them arrested anyway is if it's an emergency. So normally, when you send the summons, the Attorney General can sit on it straight away. So it's not that they're changing the law, they're looking at the fact that if you want to arrest somebody in an emergency, how can they get the Attorney General to come in at that point? I think that's what's going to change. Because don't forget, this arrest warrant, to actually arrest them, you can only get it if if the person might be leaving the country immediately. So that's the little loophole. So normally, if Tony Blair or if she was coming to the country, you would issue your summons, which means somebody comes along. And don't forget, war criminals, don't have as much rights as all of us. In the old days, if you went to have to come to court, you couldn't just be arrested by the police, locked up and held in the magistrate's court. You would be summoned. Turn up tomorrow or turn up, and that's the summons. And it's only if people think you're going to do a runner that you then have a warrant attached to the summons to make sure you come to court. So the only thing that's changing there is that I think they're going to have it so that somebody has to, in the government, has to be notified before a warrant without arrest, an arrest warrant without bail is issued. Anyway, that seems a little too bad. I was halfway through. I haven't quite finished. What was I going through the process? Before your question, which was halfway through a process about the Human Rights Act opera. Oh yes, you couldn't deport people because they were going to be tortured. So they had to stay here. So they brought in control orders. The highest court in the land said control orders were a piece of legislation that was contrary to the European Convention. 1, and 2, because it only applied to foreigners, it was also against that part of the European Convention. Because most people forget what Article 1 of the European Convention is. And Article 1 is, it applies to everybody in your jurisdiction. That's very, very important. The penal court's having one rule for foreigners and another rule for British. No, the whole point of the European Convention, Article 1, it does apply to everybody. And basically, it was only foreigners who were going to be locked up because they couldn't be sent back home because they were dangerous. So they got over that by simply saying, all right, well, you can all be locked up. So at least it wasn't discriminatory. Well, let me just finish, because last time I forgot where I was going. And then, and they also then altered it so that now, instead of locking people up, you have these very fierce control orders where they're in their houses, curfews, 24 hours a day or whatever, and that has been considered, or hasn't yet, it's been challenged again, but probably the European Court will consider that adequate because they're not actually locked up in prison and there are reasons for invading their rights to association and so on because of the so-called terrorist threat, which has been considered in a secret tribunal which might be allowed. But just to finish, that's an example of how the Human Rights Act worked. The House of the Supreme Court declared the legislation allowing foreigners to be locked up was wrong, and so they had to change it in that way, so they can all be locked up, and actually can't be locked up, but you can have a curfew and be monitored 24 hours a day. It's not good.
Well, no, it's just a whimsical thought that if everybody in your jurisdiction has to have the same rights, it seems to me we're discriminating against nuclear workers. We all know how we all like nuclear workers, but actually the poor chaps have got to put up with a dose limit of 20 millisieverts, whereas ordinary people, only have 1 millisievert. And so it seems extremely discriminatory against nuclear workers. And couldn't this be some kind of legal issue?
Are you saying they're allowed to have more than we're allowed?
Yes, much more, 20 times more.
Presumably they volunteered to do it.
Surely, we look after children. If children volunteer to eat cyanide, we have to stop them eating cyanide, don't we? If we stop people committing suicide. So that isn't an argument, is it?
No, but they're not children.
Well, no, they're people who want to, people who want
Well,
to
they have children.
But people who want to commit suicide are not children either, but we stop them doing that. We pull them back from the edge of the cliff and say, no, come and have counselling.
I'd say dignitas. Yes, that's the thought. Yeah.
I've got a totally almost irrelevant question, but as you're a lawyer, and it might well apply to quite a few people here. I'm happy to be an
I give you
employer.
criminal advice. I don't need to tell the police. I've got my card. You can have a word later. Don't you get legal aid?
Well, I've got a question for anybody in trouble with their employer, which is if you leave your job now voluntarily, you don't get the dole for quite a long time as a punishment.
Is that right?
Yeah. But what happens if you leave your job voluntarily because of bad practices by the employer, or for a, so to speak, good reason?
Well,
just a little question about the dole.
You've got to get into constructive dismissal. This is all legal politics.
Yeah.
You have to get into constructive dismissal.
But what about that?
Means they're so beastly to you, in effect, they've sacked you. Well, I suppose if you're getting heavily, yeah, that's how you have to. See, the point about all this legal politics is, the truth of the matter is that it's all been cooked up. When I did a little bit of personal injury law, the person representing the person who'd injured was sort of young and goofy, didn't know what they're doing, and the man for the insurance company was older and wiser and being paid more money. And he won the argument, and all the legal arguments, the money has moved the law in the direction that favours the insurance companies, or, So the whole thing was just a huge, massive stitch-up, really.
But couldn't you say the same thing about the International Criminal Court?
Yeah, you could, but the short answer is it is still better than no law.
Is it though? Because it doesn't. Don't you think it? Just to be the devil's advocate here, isn't there a risk? Isn't there a risk that by legitimising Victor's justice, it actually encourages people not to think that you've got to keep the law, but to think that if you want to break the law, you've got to have America on your side, and then you'll be able to get in the shadow of America's impunity, as happened, for instance, with the Croatians. There was an amazing example of ethnic cleansing by Croatia with the support of NATO, which wasn't prosecuted. So to me, that means that the accusations against Milosevic were fundamentally, before you even consider them, flawed, because they weren't applying the similar values to Milosevic's enemies.
Yeah, that's right. Yeah, it's selective enforcement.
Yeah.
That doesn't undermine the fact it's still worth going after Milosevic. But the point, I kind of just before we international law started, the whole, we all know the international diplomatic world is essentially anarchistic. Might was right.
Yeah.
And I mean, I do think the recent growth of international law, it's bugger all, it hardly does anything. Is actually really quite an interesting and belated response to globalisation.
But do we
have a wise response to the globalised shitty world in which we're all living?
But do we have to endorse, to get to that golden end that we all share, do we have to say that the International Criminal Court is a good thing when it isn't?
Well, nothing, it's all a crappy world. I mean, anything that anybody organises. We all know how.
But you seem to be quite keen to go after Milosevic. I'm saying we shouldn't have gone after Milosevic unless we were going to go after the Croatians.
No, I don't accept.
By going after Milosevic, we made things worse.
It's the same as everybody. You go after the people you can go after. It's better than going after nobody.
No, I don't agree with that.
Very realistic.
No.
I think I have a solution to your trouble here, because it's no good putting plasters on something very ill, huh? So let us create a very well system. That's what we're trying to do. We're trying to create a healthy system, which we all come from. Our predecessors lived in some kind of ecological systems, and we can all feel back to our predecessors and get the information from the source. But the point is, concrete questions. We have several very specific tasks, judicial tasks to deconstruct this sick world. And one of them is to deconstruct the financial system that is not giving us the means of finance. But the concrete question I will put at your hand right now is how to deconstruct the lack of media. We don't have access. The people who know how to do right don't have access to media, because the little tribe, the corporate tribe owns it. And the other thing is, how do we change the voting system like that? We have to change it fast, because right now we have 1% of party people, even less, people who are in parties, who commit to party system, they are only ones to be elected.
2.5 minutes is yeah, but
So the point is, how do we deconstruct the party system lawfully, so that every person in the country can be elected? Every individual, that is your lawful right to represent your sort of region, isn't it?
you see, I think, I mean, to go back, I deal in the mucky world, and I think I'm prepared to get in the sewer, and I think pissing in the wind is not better than pissing at all. It's better than not pissing at all. You've got to have a go. You've got to, and things are better. Tony Blair is a bit worried. I mean, people about being indicted. This our case about saying that we were preventing an international war crime, and therefore Margaret Jones and Josh Richards were entitled to try and blow up planes. It all sounded a bit of a long shot when I started on this. Everyone went, oh. But actually, as long as you can get it before a jury, suddenly the jury system starts to work. So it is worth having a go, but you've got to be realistic.
Yeah, okay, well you can do both. Can't
Yes,
you?
of course you can.
I mean, one way in which, when I was in 1994, when I came to the Green Party, and the question was, what can we do? And one thing that we can do is create, like I come back to this point, create alternative institutions. So whilst you attack the institution that's already there, you can set up an independent institution. I mean, I was in Paris about a month ago at the Museum of Paris. The Museum of Paris is all about the French Revolution. So everything there, you have all the original banners, you have the hats of the people, of the sans-culottes, you have the pictures of Charlotte Corday and all that. It's all there. And what you see is the energy that created that system, an ideology from square one, and you see the documents that were behind it. So we can create our own documents, that's the point. We can create an ideological document so that when you lie down in front of the digger or chain yourself up to Hinkley Point, and I'm going to talk about that this afternoon, because that's Agincourt as far as I can see, and if we get enough troops at Agincourt, Hinkley Point, we can stop those bastards. We can stop the French invasion and the nuclear industry invasion and all of those things.
Which is in Somerset, yeah.
Yeah, but we do have to have the document. We have to have the rights of man document. And so that's what I suggest, that we have an alternative judicial document, we have an alternative financial document, we have an alternative social document, all of these things in one. Actually, the Green Party's done most of this already. But we can turn that into another document and have it as the new declaration of the new ideology of human rights, and then have a new court, and we can try all these bastards and send them to virtual jail on the internet.
To rehabilitation.
Virtual rehabilitation for 7 years. They can be banned for 7 years for things.
Things, yeah, I like that.
7-year curfew.
But still, what about democracy? 1% over 99%. You didn't answer my question.
No,
You talk about democracy, European justice, human rights, but 99% cannot be elected.
Great statement. I don't deal with democracy.
I deal with laws. Well, don't think it's a democratic system. I'm not saying we've got a democratic legal structure.
You're not? Okay, that's an answer. Okay.
I think my problem with sort of greater power to international law, isn't it just a sort of another step up and maybe more oversight, more power, more centralised power? Wouldn't it be better to go in the other direction and have a lot more oversight from sort of all the normal people with smaller courts, more common, smaller courts, less of a focus on punishment through prisons and this type of stuff, more emphasis on rehabilitation and therapy? Wouldn't that be a better way?
They're called magistrates' courts, and I've seen some of the most heinous offences against justice. I mean, there's a certain extent about reinventing the wheel. I mean, people have been trying to invent democratic structures and legal structures. People have been sitting about having this sort of conversation for years. The Levellers did it, Cromwell's army did it. No, I think, I understand the fear about it, but I think it's a response to globalisation. I think you have to have international legal structures, because ultimately the nation state is a relatively modern concept, and the problem is that all of the old legal structures, such as under feudalism, hierarchy, those sort of codes of conduct that were not based on national sovereignty, that you had to answer to the Pope, that were different. And national sovereignty came in, is that basically a government could do whatever it liked in its country because it was sovereign. And that's been an incredibly dangerous concept, because you get these little pockets of people who are answerable to no one.
So I guess what you're saying is that because of the nation state, it's impossible really to have a working small or small scale law.
No, you see, I think but this comes back to, thank you for asking this question, which is what the subject's supposed to be about, which is that in fact you can use local courts to try and incorporate international concepts, which is where we came in. I think we should try and do that. But so the point being that you rely on an international court to make a ruling, and then you can, in theory, go to your local magistrates' court, which has sometimes been successfully argued by nuclear protesters. Not very often that, you know, that there is so much radiation going on that therefore you have a defence to some crime. But it's something of an uphill battle. But you can use international laws sometimes to get you off in your small local courts, but not very often, because the system's just geared to stop you. So on that rather depressing note, anybody else? Anybody else? And lady in red, probably, perhaps a more spiritual way of dealing with the problem, would always go appreciated. A more wholesome. Get away from all this legalistic pessimism and let's have some spiritual. Tell us how we could do it with our hearts.
I was just thinking that you were on the right track there. If we could balance it up and have the global issues, but connect it to the local power, where the local people can organize themselves in a powerful structure that can always veto if it is against their best and welfare and harmony, then they can veto international decisions too. Because right now we lack that possibility and it's being deconstructed. But we will take the power back. And we are creating the system. It's called Sun model. It has 14 grades of competence. And every one of you have to get active and protect your people. Because nobody else will do it. We will.
I have to say, I think we have to end on a button, actually. I can't go this spiritual uplifting stuff. We have to live in the real world. In my real world, if we were to, we used to talk about this in the Green Party, devolution to the smallest unit. The problem with being able to veto something, a law, an international law or a national law, to be able to veto at the local level. I mean, when I first lived in Wales, I can tell you that if there had been a local law there, I would be in deep trouble. Because the local people, the local Welsh people, would want to kick me out or drop me in the sea or drown me in a well or something like that because I was an English incomer. So we do have problems with small units of decision making because it doesn't.
The lady there wants to go. Yes, I think frankly the tyranny of the parish is the worst of the lot.
I was just going to say maybe the answer is for us to put forward ourselves as magistrates. And then maybe we can change things. Because my view of magistrates at the moment, they are very much the status quo and are very unlikely to support the things that we want.
Yeah, no, yes, but fate worse than death being a magistrate, I thought. But you should do, you'd be very good at it, Penny, actually.
Well, I possibly approved, I don't think you know.
Well, that's the trouble, you would be approved, exactly.
I can see you on that TV programme, you know, like Judge Penny. You know? These people come in, you know, they say, "Oh, I can't stand him, he slept with my sister." And, you know,
don't forget, the Green Party, the activists are, in our activist days, we were using legal tricks all the time.
Absolutely.
But alright, just to finish on a positive, no, you want to say anything? No? Well, the poll tax, for those of you who remember, those of you who don't, no one remembers the poll tax now. Well, I'll finish on this story. This is my one and only true claim to fame. Is I happened to be in the right place at the right time at the poll tax time. And I just started in the magistrates' courts doing this stuff. And I knew that everything spent there was incredibly complicated. And when they brought out the poll tax, originally the poll tax was going to be collected via the county court. They then moved it to the magistrates' court. something, computer evidence, just pick out in a law, fine. There's something called hearsay. Who doesn't know what hearsay means? Oh good, you all know what hearsay means, that's great. But what it does, for those of you who don't, it means that, for example, if you write in a book, a diary, I saw somebody stab somebody else, and somebody else gets that and reads it out, it's not evidence, because it's what I said, not what the person saying it said. I have to say it. The same is true of a computer. If you type something into a computer, and then it gets printed out, it's not you saying, I put £50 into the till, it's the computer with a record of what you said. So computer evidence is not admissible unless specifically allowed by statute. They've done that for all the various courts. They've done it for the criminal jurisdiction of the magistrates' courts, but not for the civil jurisdiction, which deals with domestic matters and the collection, as it turned out, of poll tax. So we discovered that the computer printout that they said you owe so much computers was not admissible in court, and we argued that. And we went to 50 courts, we argued that, and we went around the country doing seminars explaining to people how, of course, everybody got it completely wrong. They all stood up and said, you know, blah. And that was the legal basis for the non-payment campaign. And it is, I have to say, and it's, if ever you can think of a better or more successful campaign, I would be surprised. Because with this particular campaign, you know, like campaigns, you have to go for a march, or write a letter to your thingy, or do something. But with this, right, you did nothing. You just did nothing. And the thing you didn't do was, you didn't pay your tax. And that's why it worked. Whoa, no. So you just didn't pay money. And 1 in 3 people in the country didn't pay the poll tax. It brought Thatcher down, together with the Europe thing, the two things brought down Margaret Thatcher. And that was because we found a legal loophole which gave a legal justification for non-payment. Anyway, on that triumphant listening, thank you very much. Thank you.